path and calling a live witness for everyone.
Okay.
Here's what we have. One of the states, one of the deponents in the case, Cindy Fain, was somebody I think the defendants designated, and we had designation deposition testimony that both sides did and counter designations. Yesterday, during the Bagley testimony, the defendant showed the witness a little snippet of that deposition, and we objected because they didn't show the whole thing. And they had referenced this testimony in their opening statement, but then just showed it to the witness. And so at this time, I think it would fall under the rule of optional completeness actually, but rather than call Commissioner White to just rely on that testimony, we would offer to read it into the record. It's like 3 pages. So that would be our rebuttal evidence. We think the use of the testimony the way the defendants did was improper and misleading, and so that's the purpose of rebutting it.
Actually, this doesn't rebut the part that was used. The part that was discussed with the witness had to do with diversion. This has to do with the scheduling of tramadol. It could have been put on in case in chief. I was surprised, frankly, it wasn't. But if they're going to introduce just this part, we have counters to it based on the rule of completeness if the court is entitled or inclined to hear it. If the court is inclined to hear it, we would ask that we be entitled to give us a few minutes or whatever. More than a few minutes. Later this afternoon, we can submit to you the part he's going to read and our counters to it, and you can just take it up if you decide that you're interested.
May I respond to that?
Yes.
So this is a problem we've had with the defense, and this is not directed at Mr. Ottaway in any way, but we see things that are given to the court and they're just kind of letting the light in and not the whole thing. And what was just said, it's being directed by others, it's not what happened. The testimony yesterday was about diversion, and the testimony we'd like to offer the court is a direct response to that, who talks about if there wasn't a demand, there wouldn't be diversion, and she talks about the pharmaceutical industry's role in creating that demand. It's 3 pages. They chose not to offer the testimony. They know this witness now lives out of state. They knew it all along. We informed them she lived out of state. They didn't want to call her. They didn't want to play the whole video because they know that our counter designations dispel these notions. And so what they did was they had a witness get up there over our objection and read a snippet of the testimony. And so it's only fair that we read back in what else was said. That's, I think, what we need to do. But that's the only offer we have at this time, Your Honor. What we could have done is had Commissioner White do it, say, hey, as an expert, you rely on this stuff, you heard it, it was incomplete, and she could get up there and we can do that. Call her for this one purpose, let her read it, and we'll be done. Or I can just read it into the record, or you can decline to hear any of it, and we'll just make an offer of proof. Any one of those is fine with us.
Make a counter proposal. Put the whole deposition in, and you could read it at your leisure.
They chose not to do that in their case in chief. That's their mistake.
The whole deposition, put it in. If it's rebuttal, you can see that. You can read the whole thing. No hiding, no laying behind the log or anything. Just put the whole transcript in.
Mr. Beckworth, the pages that you proposed to read, were those, did the defendants counter designate pages specifically related to what you would like to have read into the record?
I'm going to answer that as clearly as I can. The way I understand it is we did not make our affirmative designations to that witness. They did. These are our counters to their designations. Am I getting that correct? Yes. So I'm looking at
I agree
my
with
jury
that.
behind.
They did not designate any part of her testimony. We did.
That's correct.
And so these would technically be their counters. But I say let's do away with all of that. Just take the whole deposition and read it for whatever it's worth if you're on the list to.
I think the fair thing to do would be to allow for the state to read this testimony. I allowed for the defendants to bring it up in the witness testimony yesterday, and so I'm going to allow Mr. Beckworth you to do what you're asking to do.
Thank you, Your Honor.
Your Honor, do we then get to provide you with our affirmative designations to what they're saying in server level?
insert rebuttal?
I've never heard of a SIR rebuttal. These are their designations.
It's just completeness.
Why didn't y'all offer the whole thing?
I have just offered the whole thing.
But you rested first.
Well, actually, I don't think I say I rested, but we went ahead with your
Whatever you call it.
rebuttal anyway. But I'm happy to offer the whole thing. And I fail to see the objection to it.
I heard your ruling, Your Honor, so
That's my ruling, I stand on it.
thank you.
So, Your Honor, our request for
It's denied.
is denied.
Yes.
Thank you very
Even
much.
the affirmatives, this is counters to our affirmatives that have not been heard by the court. Can we have our affirmatives that pertain to this testimony put together? We can do it within an hour, Your Honor. These are counters to testimony that you have not heard.
So that's not what I understood Mr. Beckworth to represent.
So
These-
my understanding is that we have broader affirmative. There was only a couple lines that were presented to the court yesterday. It was not the totality of our affirmative designations. They have countered testimony that was much broader than was what was presented to the court yesterday. We would ask for the opportunity to put in the affirmatives that pertain to these counters, because that would be at least a fair picture of the testimony. Allowing them to excerpt and put in just counters would not be appropriate, Your Honor.
I've got a solution that I would like to propose. Is that okay?
Go ahead.
So first, just to hear this argument, you know, the witness that they put on today had one of the most broad disclosures in the case, and they made a choice to just call them on narrow issues. That's a choice that's made. So we can only cross-examine that witness based on the narrowness of whatever they chose to do. That was their right to do during their case. So while they designated an awful lot, we had counters, and that's what this is. Now, I don't want any argument of error in this case to be artificially created by anyone. So here's what I would propose we do. We'll read this in now, and we'll be done. We'll have no objection if at some point today or whenever they want to submit the whole part of their designations and ours in writing, just as Mrs. Strong offered, and then there will be no problem with what they're saying. We have no problem with that. We'd like to go ahead and be able to close it up, but I'm sure that Your Honor will allow a submission later today of that. That is the written stuff, exactly what she's asking to do, we'll be fine with.
And if, Your Honor, you're going to allow the evidence to come in an hour, I think we can wait to have it come in together. There's no reason to have it out of context and to have this read into the record and open court and have the other components submitted in writing. It ought to be done in the same manner, whether it's all in writing or whether it's all in open court. And we can, we can tailor down the affirmatives that we initially offered to make sure it's only pertinent to the counters that you're offering, so it may not be the totality of the affirmative designations. We did not know that they were going to be doing this, so literally we looked at it for the first time, Your Honor, right now. We will do everything we can to make it as short and as concise as possible. To give us an hour or so, I believe we can do that, Your Honor.
If that's the case, we'll just withdraw our offer and call Commissioner White. We'll have her do it as an expert and rely upon it, because this is just more gamesmanship. I literally offered to give the entirety of the deal as they asked, and now they want to do something different.
Well, I'd like to, we're all here now, I'd like to proceed. Ms. Strong, I understand where you're coming from. You weren't prepared with this, and I'm not going to hold that against you. The other option is to allow you to submit those portions as a written offer of proof that will be treated by me, just as it would. I'll give it the same attention as it would had it been presented here in open court.
That's fine, Your Honor. We'll submit them as soon as we can this afternoon.
We accept.
Yeah, yes.
Okay.
And we
Thank you, Mr. Strong.
thank
So
you.
why don't you go ahead and
Yes.
read.
And just to be clear, we have no objection to that and providing the full designations that both sides did. We have no problem with that. Thank you very much.
Thank you.
Your Honor, I'm reading from page 209, line 12. This is the testimony of Cindy Hamilton Fain that was taken on February 19, 2019 in Little Rock, Arkansas. Question. Ms. Fain, earlier today you testified to some examples of what you consider to be misrepresentations regarding opioids. Do you recall that? Answer, I do. Question, do you, based on your experience with the Board of Pharmacy, know whether pharmaceutical manufacturers made those misrepresentations to doctors? There was an objection. Line 20. Answer. They had drug reps that were going out to doctors and to pharmacies and teaching them, like this is the best drug to treat this illness. It's for chronic use or acute use. And I think that, I heard many times if it's prescribed for legitimate pain, then you won't be addicted. And I don't think that was truthful. Question, do you believe those actions taken by the pharmaceutical companies, sales reps, with regard to doctors and pharmacists contributed to the diversion of opioids? There was an objection. Answer, line 7, page 210. I feel like if there wasn't a demand, then there wouldn't be diversion. So, if we on the regulatory side are trying to put in stopgaps and restrictions for access, whether that's, through the prescription monitoring program, or that a Schedule II prescription has to be a written prescription and it can't be phoned in, and insurance companies would, put limits on it, but there was still a demand, and if it wasn't being met legitimately, then it would resort to being diverted and people would gain it illicitly. Question, is it your belief that the pharmaceutical manufacturers were generating that demand? Line 21, there was an objection. Line 22, page 10, 210, answer. I think that they contributed to it. Question, from 1998 to 2018, when you were with the Board of Pharmacy, what happened to the number of incidences of diversion related to opioids? Answer, line 1, page 211. It exponentially increased. So like at the beginning, when I first started in 1998, I think we had maybe 25 cases per year. And then by 2008, we had probably anywhere from 75 to 100 cases per year, and a good majority of those, probably 70% of them, were diversion related. Question, related to opioids? Answer, controlled substances, but yes, opioids too. Question, okay, it's stricken. Ms. Fain, do you recall any instances during your time with the Oklahoma Board of Pharmacy where a pharmaceutical company directly worked against an effort by the Board of Pharmacy to curb opioid diversion? Answer, yes. I can't remember the exact year, but maybe in 2005, 2006, I was seeing a lot of reports of pharmacists that were in recovery that had relapsed on tramadol, and there were forged prescriptions for tramadol. But it was really impossible to track the numbers completely because it's not a controlled substance, and so it wasn't included in the annual inventory that the pharmacists were supposed to make. So even if some was stolen, you couldn't really account for it. How much was stolen or how many forgeries were going, because it wasn't being submitted to the PMP. So I took these anecdotal stories to the Board of Pharmacy and asked them to make tramadol a controlled substance. And McNeil, I think that was the manufacturer of tramadol, and they sent representatives to the board to argue on behalf that it shouldn't be a controlled substance. And I was young and naive and probably didn't do as thorough a job as I should have. Didn't realize there would be any opposition, and it did not become a controlled substance. Question, line 10 on page 212. And McNeil is, do you understand that to be ortho-McNeil? Answer, yes. Question, and is that, to your understanding, a Johnson & Johnson entity? Answer, that's my understanding. Question, do you believe efforts like that one from pharmaceutical manufacturers contributed to the diversion of opioids? There were 2 objections. Answer, page 212, line 21. Absolutely, I do. Your Honor, that completes our submission. I appreciate you letting us do that. We have no further rebuttal evidence at this time, and at this time, on behalf of Mike Burridge, Reggie Whidden, General Hunter, Commissioner White, Abby Dillsaber, Lisa Baldwin, and all of our team, I'd like to thank you for this great honor, and thank you and all of the folks that work with you for allowing us to be here this long. Your patience is pretty remarkable, the hours you've let us keep to get through this and to get through a little bit early. So we thank you, and we look forward to closing arguments. We're ready to do them now, but if you want to have us wait, we'll do them whenever you're ready.
Thank you.
Thank you, sir.
Mr. Beckworth, appreciate it.
Okay. Well, I'll give you a copy in just 1 second.
Okay.
Just very briefly, Your Honor. I didn't specifically hear the state rest its rebuttal case, but I assume I can take the closing
Mr.
comments.
Beckworth, you want to clarify that for us?
That was a rest.
Okay, we'll note the state is rested.
Your Honor, and we will, as discussed, submit the Hamilton Fane testimony. We'll get that into Your Honor today to address the points that were read into the record. I believe everybody on our team feels the same way, just in terms of thanking you for the way you've guided us to this point and the way you will no doubt continue to guide us through closing arguments on Monday. As a procedural point, now that the state has rested its rebuttal case, I'll re-urge the same grounds that I specified in support of the motion for judgment that we made before the lunch break. The brief that we filed, which is now on file, addresses those points as well. Nothing that the court heard from the reading of Ms. Hamilton Fane's testimony or the brief clip that was played from Mr. Martin, I think impacts or changes our entitlement to judgment on those grounds. And we understand that the court will likely want to take this under advisement as well. We simply ask that the court do so without waiver of any of the arguments that were presented this morning and are being re-urged right now.
Mr. Brodé will go ahead and take your motion for judgment under advisement and note that does not waive any rights that you have, and I'll make that ruling at the same time as I make my other rulings on this matter.
Thank you, Your Honor.
Thank you. That will conclude our proceedings today. We will go ahead and adjourn for the rest of the day. I'll see you Monday morning. I've allotted the state 2 hours for its closings and defendants 2 hours. I anticipate we will start promptly at 9 a.m. And then I anticipate taking a lunch break and then giving the defendants their 2 hours following lunch. I'd like to think we'll start right at 9 and then right at 11, but we may go to 11:30, but we'll adjust our lunch schedule, so it may not be right at 1. It may be 1:30 before we start with you, but the plan anyways is 9 to 11 for the state and 1 to 3 for the defendants, with a little bit of flexibility built into that. Mr. Whitten?
Yes, Your Honor. We neglected to discuss with you our rebuttal. We'd like to have 30 minutes rebuttal time for response to their closing.
My ruling on that is I'm just going to give the state 2 hours all at the same time. I'm going to deny the request for rebuttal, but I will let you split it up between people like you did the opening.
So just real quick on that, 2 hours total, but will we be able to allot part of that time to rebut? Mm-hmm. So we can say
I'll let you do that.
Okay.
Yeah, but it's
I
that will be in
understood
addition to the 2 hours.
2 hours in the morning for them, 2 hours in the afternoon for us.
Well, I'm allotting 2 hours each side. If the state elects to not use its entire 2 hours and save some for rebuttal, I will give the state that opportunity. All right. Any other questions about closings? As we previously discussed, I think at the pre-trial conference, I'm sure you'll remind me on Monday, but I am anticipating that the parties will submit written findings of fact and conclusions of law. I know you're going to ask for more, but I'm going to probably expect those 2 weeks after closing. So you can make your best attempt to ask me for more time Monday, but I probably will deny it. Other than that, I thank you all, and we'll call it a day. See you on Monday. Thank you.